Good morning and welcome to this seminar. Today is Wednesday. I was watching the governor's press conference on Sunday, and I was a little relaxed until he started going into these incredible mandates to be conduct testing of employees twice a week. My heart palpitations were getting, quicker and quicker. And that was Sunday. An executive order 202.30 issued that evening. We had your administrator letter that was issued today. A survey was implemented by DOH and HER on Tuesday, and the Ask Questions document was issued yesterday. Plus, there's rumors rampant about whether this is going to be delayed, whether this order is going to be rescinded. We are operating under the assumption that it's go, green light, we have to proceed. So, just as we thought that we were getting over the hump and starting to deal with the problem, we have a huge problem to deal with regard to logistics. This webinar will focus on readiness from the labor perspective, because I think there will be more standards and more criteria and guidance presented by DOH, but we have to start getting ready. We can go to the next slide. These are just some of the items from the news conference. Pretty blunt. Nursing home staff must be tested twice a week. If any of these procedures are not followed, lose your license. Again, tracking type way of notifying the industry of these issues. Go on to the next slide. So as lawyers, what we start to do once we see the paper and the executive order is start parsing through and figuring out exactly what the mandate is. So I have on the screen scope, actions, and who. What scope of this order? Well, the scope applies to nursing homes and adult care facilities, which are assisted living residences, homes for the aged, enriched housing. Actions, what actions are required? And here we want to be very careful exactly what is required. I have that in red: to test or make arrangements for the test. So when I saw that, from a perspective of readiness, I said, okay, we don't have to immediately test all of our employees twice a week. On top of the fact that that's an impossibility, let's focus on making arrangements for testing. And who needs to be tested? Personnel, which includes the employees, medical staff, operators, and administrators, twice a week, with the submission of your plan today, which is today, May 13th. So, these very brief mandate, which has now been expanded upon, through the DO, frequently asked questions. So we're starting to learn what type of personnel is there. Do we have to test everybody who passes the threshold of the to our facilities, and the timeline is a mandate. Pursuant to this document, the order itself is mandatory. There is no specific. Let's go on to the next slide. What's not answered by the order or by many of the documents that I've seen thus far is how, when, and who will be doing the testing. Those are the unanswered questions. And over the past week, we've been hearing that nowhere in the state there is sufficient capacity to do this type of testing. Counties are up in arms. They can barely do the testing for symptomatic cases. Who is going to do the testing? Is it going to be the laboratory? But where are the samples going to be obtained? Pharmacies, hospitals, at the facilities themselves. What is DOH's role? One of the rumors that are running around is that perhaps DOH is going to take over the cost, and perhaps that's probably wishful thinking, based on the frequently asked questions document that came out yesterday that indicated the facility would be shouldering the cost of this. Go to the next slide. If you can go to the next slide, Kathy. So bottom line is, from a readiness perspective, we're looking at what is it that we have to do. We have to go back. From a readiness perspective, we're looking at medical orders, consent, workforce transparencies. We'll get into that with Sanjeev and in a minute. Critical to have lines of communication with employees. Obviously, they're looking at the preferences. They're wondering, why aren't you testing me twice a week? Am I being protected? What's going on? So from our perspective as facilities, what we're trying to do is put together a realistic plan of action, which means making that are specifically set forth in the executive order. My perspective is we need to start this task in a realistic way to try to do what's possible and not what is impossible. One of the last things you want to do is establish policy or make promises that can't be kept. And as you can see, there's insufficient capacity testing with regard to supplies, with regard to even in the laboratories that would provide the results. Go on to the next slide, please. On top of all this, public opinion is informed. So I think much of the public may not realize what the problems are here. So we have to tackle from the facility standpoint a public opinion or a public relations fight as well. So in my view, it would be the wrong to be complaining, at least in terms of, and even with regard to employees, with regard to the concept of testing. My own personal opinion is I don't know what's effective. I haven't seen any science. Bi-weekly testing, I don't know where this comes from, but be that as it may, it is law at this point. Ultimately, what the public is concerned about, they're looking at flattening the curve. We have an image of the 1918 pandemic, and it shows the contrast between Philadelphia and St. Louis. And Philadelphia, as many of you may have seen, huge parade. They did not practice any social distancing, and they were decimated quite literally by the back. St. Louis had better outcome. So everybody's looking at flattening the curve and avoiding an outbreak. The ultimate goal, and I think this is what the concept of testing. Once the testing is done properly, and it can be done within 15 minutes, and you get the results in and there, it would be effective. We're nowhere near that, as far as I can tell, from surveying clients around the state. But that's the concept, and we should start using this as to train up for that as we go through this time of turmoil. We'll go to the next slide, please. So we wanted to start with a discussion of some labor issues which arisen, and start to understand these labor issues, because I think those are going to be forefront. We know that the logistics are such that it's an impossible task, at least to do it within the next week, 2 weeks, 100%. But the labor issues are going to dominate, and probably are starting to surface very much so immediately after. So I'm going to turn it over to Mark Maldenauer, who's within our labor practice, and Sanjeev D'Souza, also within our labor practice. Mark is in the Buffalo, and Sanjeev is in the and I'll start off with Sanjeev to start off a discussion. Sanjeev?
Okay, thanks, Raul. And thanks everyone for joining us this morning on short notice. Hopefully you can hear me fine. The first thing I wanted to just briefly touch on is, the notion of, which personnel are required to be tested. And Raul mentioned it briefly. The executive order identifies groups of individuals sort of generally, employees, contract staff, per diem staff, medical staff, et cetera. There were FAQs issued yesterday that provided a little bit more clarity on who are the personnel, at least at this point, possibly subject to change. The FAQs mentioned a couple of things that I think are worth mentioning now. One is, and this may be fairly obvious, but if you have staff that are working from home and are not coming on site, they don't need to be, they're not subject to this testing requirement. And then the question comes up for many facilities because you have, a pool of part-time or per diem staff. How often do they need to be tested? Are they subject to this 2 tests per week requirement? And at least according to the FAQs, it indicates that if you have an employee that's working 3 days per week or less for you, you only need to be tested. That person needs only to be tested 1 time per week. So that, provides some additional information. They also include a notation that staff of home health agencies, LICSAs and CHAs, as well as hospice agencies which serve patients residing in the facility. The staff working there are not personnel who have to be tested under this executive order. So I think worth mentioning on that point. So then, Mark and I were thinking through, some of the other issues that come up as a result of this order. One of them is obviously, what questions such as, what happens if an employee has taken the test and is awaiting the test results. As Raul mentioned, we're not at a point where the test results are immediate and you're getting it in 15 minutes or so. There can be some lag time. What do you do with those employees while you're waiting for the results? And the FAQs, again, provide a little bit of information on that, and they distinguish the employee who is taking the test is asymptomatic, and the reason they've taken the test is solely to maintain compliance with this executive order. The FAQs say that employee can be allowed to continue working while you wait for the test results. Now, obviously, distinguish that person from the employee that might have some symptoms, and that's why they're going for the test. In that case, then you need to comply with the department's requirements in terms of keeping that person out of work until certain criteria are met. Mark, anything you want to add to that?
Yes. Again, thank you for joining us this morning. I'll before I kind of build on what Sanjeev was saying, I'll just make the comment that, as labor attorneys, we like to try to be as deliberate as possible in terms of addressing, personnel or potential, proactively preparing for personnel issues. The circumstances of this executive order don't necessarily allow for that in the manner that we would like. Obviously, this is very hurried. To echo what Raul had said earlier, I think we can all agree that the objective, the purpose of this comes from a good place. It certainly doesn't make it any easier to implement it operationally or to make sure that we're developing solid strategies for dealing with this in every single respect. So to a certain extent, we just have to be flexible and adapt as necessary as more information becomes available to us. The one thing that I will kind of build on from what Sanjeev was saying is that at its core, this is really the obligation for the facility to satisfy this requirement. The burden financially is on the facility, operationally it's on the facility. Perhaps more assistance will come, but at this point we don't know what that is. What is important as far as conducting the testing is being able to document that we are in fact satisfying the requirement, whether it's twice per week for most employees, full-time employees. And when I say employees, I mean that in the most broadest sense. All personnel, staff, per diems, administrators, operators, anybody who's on site. And then as Sanjeev said, if somebody's only on site for 3 days, that's 1 day or one test required per week. But again, that needs to be documented. The issue may come up with somebody, somebody who's working at a facility that works for multiple employers. The coordination for that is something that we need to spend some time thinking about. Because again, if somebody's working at your facility 3 days a week, we want to be able to establish that they are being tested on our end, but we're also going to be asking employees in some instances to supply documentation to show that they've been tested if they were working at other facilities as well. So that's sort of information, documentation that employers have got to maintain. Another question comes up with as far as implementing this, notifying employees if they're represented by a union, notifying the bargaining unit. What sort of obligations do we have to negotiate this? I think to start out that issue, I think it's safe to say that this is something that's issued by the government. It's a requirement that's mandated by the government. We don't have the luxury of negotiating this issue as you would in most instances if there's a change to terms and conditions of employment. Testing of employees is a term and condition of employment, but in this instance, it's a government mandate. So we don't have the luxury of deciding how often employees will be tested or anything like that. The New York State government is telling us how often it has to be done. That being said, we will need to negotiate the impacts of this change with a union if at least portions of the staff are represented by a union, by those bargaining representatives. So that could take a number of different shapes. There could be a number of different issues that would be raised. At this point, I think what would be advisable is to just open up that dialogue with the union, notify them that this is something that we will be implementing consistent with the new requirements from the state. And hopefully they will be on the same page. They will recognize that this is something that, one, employers don't have a lot of control over, right? We're subject to the state mandate. Two, this is happening fast. And three, there is a public policy purpose for it all. So there's not going to be a lot of resistance. But we would anticipate certain types of issues that the union's going to raise. Some of which might be how the testing is going to be conducted, when it's going to be conducted, and what are the consequences if somebody either refuses to consent to a test, declines to participate in the process, and what sort of impact that's going to have on them and their position with the facility. I don't know, Sanjeev, if you want to address that point.
Mark, I just wanted to interject one item on contractors and vendors because they're not our employees, and we have control over them through a contract with the vendor or the contractor. And most of our contracts do require that any staff coming into the facility have the tuberculosis testing, the health examinations, PD and things of that nature. So one item in terms of, being ready is really issuing a notice, identifying all of your vendors, all your contractors that are subject to this requirement, and then advising them that, pursuant to the contract, take a look at your contracts. I'm reading one right now where we do indicate, pursuant to the contract, that they must have the usual testing, but then also comply with the requirements as such requirements may change from time to time. And it specifically mentions NPR 415.26 D1B is, I believe, mentioned in the order. So we want to make sure that we are immediately taking an inventory of our contracts, taking inventory of our vendors, and sending that notice out. And then the question will be, are they going to apply and undertake the cost of doing that for their employees? So one of the other chaotic things that will arise from this, unless we get an extension. Go ahead.
Okay, so thanks for adding that, Raul. And then to speak to Mark's point about employees who refuse to comply with the testing requirement, let's focus on the unionized employees for the moment. One of the things that you're going to want to do is take a close look at your collective bargaining agreement, and look at your management rights clause, look at your health and safety provisions, look at your paid leave provisions, all of those things to have a better understanding of how those might be implicated in complying here. Do you already have work rules in place that address insubordination, for example? And would an employee's refusal to comply with the testing requirement here fit within that work rule as far as insubordination goes? And then, what the disciplinary consequences you've imposed either per policy or as a matter of practice over time, because that will affect, what your obligations may be to bargain with the union over that issue. And that's something that if you have labor counsel that you work with, we would encourage you, whether it's us or other counsel, to consult with them and determine what it looks like your obligations are. But it does raise a question. The executive order is very clear that if an employee does not comply with the testing requirement, they can't work on site. But it doesn't go beyond that. The question of how to manage that person from a disciplinary or personnel standpoint is left to the facilities. And so for both unionized and non-union facilities, you have to think about, how do you manage this from a practical standpoint, to maintain staffing that you're going to need going forward to care for residents, while balancing against, sort of what would seem maybe in some cases to be an unreasonable refusal to comply. So that I think it's very important to look at your contract and make sure you understand the universe of provisions that might be applicable here. In another thing that I think you want to consider, and this is not limited to unionized facilities, but and this speaks to Mark's point earlier about employees who work at multiple facilities. What's the requirement in terms of how often they need to be tested? If you have somebody who works 4 days a week at one facility and 4 days a week at another, even though there's maybe overlap, they're not working full days at each place. Is the requirement that they need to be tested 4 times a week, or is it 2 times a week? The FAQs shed some light on that. They note that if the employees work in multiple facilities, they only need to be tested twice per week, but each facility is required to maintain the documentation to show that they have met that testing requirement. So that goes to Mark's point about, you may at times need to get the documentation directly from the employee, and maybe in many cases you'll have to do that in order to show that you're maintaining compliance.
Yeah, one issue to think about on the refusal. I think a lot of employers might kind of go through the natural process of thinking, geez, is discipline appropriate in this instance? As Sanjeev said, you have to consider a lot of different factors, including the impact it's going to have on the workforce, and keep the bigger picture in mind. There could be reasonable accommodation issues that need to be evaluated also by the employer under certain instances. So be aware of that, and don't be too reflexive on discipline. Perhaps that is going to be the only hammer, so to speak, for employers, or in many instances, to try to compel enforcement. But what is very clear from the executive order is that somebody cannot work. They cannot be on site unless they've gone through the testing requirement that's required on this. So that point's not to be lost. We have gotten a few questions in, and some of them, not surprisingly, have to do with funding. And I want to try to address those initially. I'm not sure how much information we're going to be able to provide on that, but at least, we are at the very early stages of this. There's going to be more information that's coming out. So, again, we have to be kind of a little bit adaptive. But the question was raised as to whether or not there's not going to be any federal funding that might support this initiative, or whether there's something that's already out there that might support this sort of requirement, or assist the facilities as they comply with that.
Kathy, could you go to the next slide? This is the last slide. We wanted just to have an introductory session on this in terms of readiness. Obviously, the views that we express are just our own. Our goal really is to stimulate a discussion, start to think about these procedures. With regard to funding, we're going to have another session, hopefully by the end of the week or early next week, once we get more information. We're looking at the CARES Act. There were some enhanced funding mechanisms included in the CARES Act successor, the first bill that had come out, enhancing reimbursement, eliminating co-pays for testing. So we're actually evaluating health insurance for employees and seeing if would be covered by our existing health insurance. We're asking our contractors to do the same. And then we're going to be looking to DOH as well to see what type of funding mechanisms. We have a staffing shortage. We have a funding shortage even for the core requirements that need to be undertaken. So this is not only sustainable logistically, but it's unsustainable from a funding perspective. So there's more to come on that. With that, I would like to thank you for listening to us.
Raul, can I just mention one point before we end? Just a reminder for everyone, you're going to be compiling this documentation on the test results. Bear in mind that the ADA's confidentiality rules regarding employee medical records and testing records applies to these test results. So just be sure that you're maintaining them in separate confidential medical record files for each employee. No, I thought that was important to mention before we wrap up.
Exactly. Also, we have a consent document that we're recommending to be obtained by the employees. Consenting, there's a whole host of logistical issues in terms of getting the lab test, having medical order for it, having the employee consent, and all of those items should be included in policy that facilities should be developing, to comply with it for the course of the next couple of weeks. So with that, thank you very much, and let's see if we can get through this. Take care.
Thank you.